Okay, on the record in the matter of the city of Lansing versus Jayla Bowers, 24L2862-831, council appearance.
Good afternoon, Your Honor. Daniel Shane for the city of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Bowers, who is joining us via Zoom.
Jayla Bowers.
Start your video.
Your Honor, if you don't mind, we are still waiting on an email from Ms. Bowers. She sent it to me earlier today or during the lunch period. I still haven't gotten it, and Mr. Duchesne needs to see it. If we could pass on her just briefly so she can make sure that email gets to me.
Okay. You're confirming if it was received or not, or sent?
That's correct, Your Honor. She did call me earlier to get my email to send it to me. I just haven't received it yet, and I want to make sure it's being sent to the right place. We do have a resolution for her today. Mr. Duchesne just needs to cover his bases and confirm that email from her.
Oh. Ms. Bowers, did you get a chance to send the email?
Yes, I did send the email, but it said that that email address didn't exist. It could have also been something on my half. I did call her back to confirm the name, so I'm unsure why it's saying that, but I do need a break room to ask her for the email again. I'm sorry.
What's the email address?
It's lsutter@ingham.org.
It's L Sutter, one word,
Yes.
at Ingham, INGHAM.org.
Okay, can you guys actually spell Sutter, her name and her last name for me?
It's SUTTER.
Can you say that one more time? I'm so sorry.
S like Sam, UTTER.
Okay, thank you. And is there anything before that? Was there an L?
L Sutter
Okay.
at Ingham.org.
Okay, I'm sending it over again right now. And let's see if it goes through.
Okay, and we'll go back to that one. This is the matter of City of Lansing versus Isaac Curtis, 23-02752. Appearance, please.
Daniel Shane for the city of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Curtis, who is joining us via Zoom.
Okay, Mr. Curtis has a pretrial for driving unlicensed today. How are we proceeding?
Your Honor, it's my understanding that the defendant will plead guilty to the reduced charge of no ops.
That's correct, Your Honor.
Is that accurate, Mr. Curtis?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the information you're going to provide is true under the penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. Okay, Mr. Curtis, you have the right in this matter to proceed to trial, and you have the right to jury trial. You can require that the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You can remain silent at your trial and not have that silence be used against you. You could waive silence at trial and testify on your own behalf, or have witnesses subpoenaed to your trial to testify for you. You also have the right to see, hear, or question any of the witnesses that the prosecution intends to call against you at trial. Those are all rights that you would have to give up in order to plead guilty to the amended count of no ops. Do you understand that?
Yes, ma'am.
You're willing to give those rights up today?
Yes, ma'am.
Anybody threatening you to do that?
No, ma'am.
Has there been any promises extended to you to get you to give up those rights?
No, ma'am.
And let's see, are you pleading guilty to the no ops because you believe you're guilty?
Yes, ma'am.
As to no ops in possession, how do you plead, sir?
Guilty.
Factual basis.
Thank you, Your Honor. Mr. Curtis, on or about September 3rd of 2023, were you driving a vehicle on or near East Grand River and North Hayford Ave?
Yes, ma'am. Yes, ma'am.
And is that in the city of Lansing, Ingham County, Michigan?
Yes.
And at that time when you were driving a vehicle, is it true that you did not have a valid license on your person?
Yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
City satisfied, Your Honor.
So the court is satisfied with the factual basis. I'll accept your plea and find your plea to be freely, voluntarily, and intelligently. You say he does or does not have a valid license?
He does not at this time, Your Honor. He is now a resident of Minnesota. They will not grant him a license until this case is resolved, which is why he wants to handle this today so we can get his license there.
The fine is $200. When can you make payment?
Next probably Friday. Can I do a
You can make
payment plan? Can I do a payment
Yes, you
plan?
can.
Okay.
Yes, how much you gonna pay next Friday?
50. That's fine.
Somewhat less than that. Somewhat less. That's right. Of course, Venus got the long hair like an Apache. So as the whole bee,
Okay, and I'll note that you'll make a payment of $50 by next Friday and then no less than $50 per month until paid in full, okay?
Yes, ma'am.
Any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Nothing further. Thank you.
You're all set, sir.
Thank you.
You're welcome. On the record in the matter of the city of Lansing versus Zamoria Forman 23-02149. Appearance, please.
Daniel Shane for the city of Lansing, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Ms. Forman, who is joining us.
Okay, Ms. Forman has a violation of restricted license that was reset to allow her an opportunity to show some progress. How are we proceeding?
Thank you, Your Honor. At this time, we'd be asking for an additional adjournment for her allowed to continue making payments. Unfortunately, since her last hearing here, she did lose her place of employment, or she wasn't able to get to work given her lack of transportation. However, she has gained a new job since then and has an interview for a second job tomorrow. So she's hopeful that moving forward, she's gonna be able to make some good progress towards that outstanding cost, which I believe last time it stood at $13.85.
Those $13.85 in fines.
Yeah, when we were in court last time, I think Ms. Nash helped with looking some of that up, and I believe that was the total amount owed to 54A. So the city wanted some proof of at least progress being made towards that. Given her loss of employment, progress has been very slow thus far, but she does have new employment now and is hoping to take on a second job after tomorrow.
And January 21st, that's in.
January 21st at 10 a.m. Do you have any questions for the court, Ms. Foreman? I can't hear you.
Can you hear us, Ms. Foreman?
We can't hear you. Something's going on with your audio, but do you have any questions for us? If you do have questions, raise your hand. Okay, no questions, then you're all set for today.
Thank you.
Thank you. Okay, let's see. Did you get your, thank you, Ms. Bowers. Okay, on the record in the matter of the city of Lansing versus Jayla Bowers, appearance, please.
David Shane.
Good afternoon, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Ms. Bowers, who is joining us here.
Ms.
Jayla Bowers.
Thank you. Your email was received. How are we proceeding on this, counsel?
Your Honor, I've received proof that defendant has been issued a driving permit by the Secretary of State according to the previous offer of defendant will be taken to federal today.
That's correct.
Reduced from
That's correct, Your Honor.
Ms. Bowers, you're going to plead guilty to failure to display an operator's license, ma'am?
I'm unsure if I'd like to plead guilty to failure to display because my phone died earlier on my attorney and it was just cutting on right before I joined court. I'm sorry. I'm unaware of the actual meaning. I don't know if I
Okay,
want to
so
plead guilty.
do you want more time to talk to your attorney?
Yes, please.
January 21st at 10.
January 21st at 10. Okay, I'm gonna reset your matter to January 21st at 10 a.m., okay?
Okay, thank you so much.
You're welcome. You have an AG case or something?
I was just looking, I'm like, wait a minute.
Okay. I'm just assuming by the name, what's happening here, but. No, it's a different matter. Mr. Dean, which matter are you here for?
I'm here on case 2403003 GC.
Oh, thank you. Right. On the record in the matter, the city of Lansing versus Gino Garcia, 24-00279, appearance please.
Danny Shane for the city of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter. I'm here on behalf of Mr. Garcia. I haven't been able to speak with him and I don't know if he's here today.
He's not present in June. I'm sure make sure. Okay, and the city of Lansing versus Jenkins, 24-02706, appearance please.
So we're case that, Aaron? Jenkins, Danny Shane for the city of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Jenkins, who is joining us via Zoom.
Okay, and today was the date set for a pretrial. This is for operating with a 0.17 or higher and a failure to stop at the property damage accident. I think we reset this for a substance abuse assessment.
Yeah, that's correct, and I believe the assessment has been completed, but the report is not issued.
That's correct, Your Honor. Michael Robertson from Crystal Ray confirmed with me that he's done the interview with Mr. Jenkins.
January 21st at 10:30.
January 21st at 10:30 is your new date, Mr. Jenkins, okay?
Yeah, you said January 21st?
January 21st at 10:30.
All right, but thank you.
You're welcome, you're all set.
All right.
Is this Sean Johnson here?
I have not seen it, Your Honor.
Thank you. Warren. City of Lansing versus Jasmine Jones, 24L29034141.
Danny Shane for the city of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Jones, who is joining us via Zoom.
Okay, and this was an open intox passenger citation. How are we proceeding on this?
Your Honor, the city's understanding that the defendant will accept responsibility to an amended charge of breach of the peace, which is a civil infraction under 664.1C.
That's correct, Your Honor.
Is that correct, Ms. Jones?
Yes, Your Honor, it is.
Fine is $50. When are you gonna pay?
I can pay that within 30 days.
I'll note that you'll make payment within 30 days. You're all set.
Thank you.
You're welcome. Mr. Shearer downstairs.
No,
He's at the 30th Circuit right now. He has a 2 p.m. pretrial with Judge Dragonchuk, wherein I, fingers crossed, think he might be taking the plea that we've been waiting in this case.
This is supposed to be global.
Yes, Your Honor, he was supposed to be entering into one of the specialty courts. Yeah, he was eligible for drug court, so I'm hopeful that's what's happening. We're just checking checks out right now.
Can reset these.
January 21st at 10:30.
So we say 10:30.
On the record in the matter of the city of Lansing versus George Zuniga Jr. And this is 2401453. This is a probation violation arraignment. The allegations that I have here, Mr. Zuniga, this is a present via Zoom, is that you failed to refrain from alcohol and marijuana for EverHealth on November 4th, 2024. You tested positive in the amount of 492.348 nanograms per milliliter carboxy THC on November 14th, 2024, positive in the amount of 11,642.18 nanogram per milliliter ETG and 3,137.82 nanograms per milliliter ETS and 653.83 nanogram per milliliter carboxy THC. It says carboxy THC increased from November 4th to November 14th, indicating new use. So you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you're found to be in violation of your probation status can be terminated. You can be sentenced to a term of jail time. You understand that?
Yes, ma'am.
Okay. Did you want to request an attorney to represent you?
No, ma'am.
You do not, you want to proceed to a hearing without an attorney, or did you want to waive the hearing and waive the attorney and plead guilty to these violations, understanding that there is the potential of a time in Ingham County Jail being sentenced as a ramification of the behavior?
No, I don't want to waive that right. If I gotta get an attorney, I'll just do that.
Well, I asked, did you want to request an attorney? We have the public defender here in the court waiting to see if you want to meet with her.
Yes, please.
Okay, so then we will set this for a hearing, and then you'll have an opportunity to be counseled by an attorney before you decide how you want to proceed. We'll enter a plea of not guilty at this time.
January 14th at 1:15.
January 14th at 1:15 in person for hearing.
14th.
January 15th at 1:15.
January 15th at 1:15. Okay.
I'm sorry, January 14th. January 14th at 1:15.
Oh, hold on. January 14th at 1:15. And go there to the court?
That's correct. But if you hang tight, and Ms. Sutter's gonna meet with you right now.
Okay, thank you.
I'm gonna add to your.
Perfect, thank you. And I caught the first violation. Would the court mind helping me out with the others were? Your positive alcohol.
I think I missed one. Oh, boy, wait a minute. I did this one. I gotta bring it back. Sorry, so we gotta need to highlight it because I signed one on the 26th. On the 23rd. I mean, on the 5th. Let's see. I asked you to put a sticky on it, I'm being extra.
Not sticky ones.
I mean, just let me know that new violation, so I know. These can get lengthy. Sometimes it gets lengthy.
It does.
Mr. Zuniga?
Yes, ma'am.
Okay, I had to bring you back because I actually have another violation I need to ring you on as well, and this one is from the 26th. And the allegations on this one are that you failed to submit to testing per AverHealth back on November 23rd, 2024, that there was an inability to produce a sample. Also, that's also a violation that you have the same rights to. I just want to advise you of that before I put you in the private meeting room with counsel, okay?
Yes, ma'am.
Okay, now I'm gonna put you back in there now.
Jesus.
Okay, there was that one, and then the other two was officially positive for alcohol. What's your name? That's the last name? First name? Okay, that was the motion. Who's on the iPhone?
Hello,
What's your name, ma'am?
Kimberly McLeod. Kimberly Woods McLeod.
Okay, Mr. Smith, I thought I saw him log in. Okay, he is there.
I'm here, Your Honor. Good afternoon.
Good afternoon, Miss Kimberly Woods is here. Did you want to go in a breakout room?
There's really no point. We had an exam in August. She was to produce some documents under the court subpoena. We sent a reminder letter reminding her what to send and where to send it. We came back September 30th because she had sent nothing and she had failed to appear September 30th. So maybe she can explain why we don't have the documents, because I can't continue with an exam until I have the bank records that were described in that reminder letter sent to her August 20th.
Okay, Lansing Automakers versus Kimberly Woods 96-00097 GC. And can I have your appearance formally for the record?
For plaintiff Lafku, Tim Smith, P48259. Good afternoon.
Ms. Kimberly Woods is present via Zoom. This is a motion to show cause. Ms. Woods, you were supposed to produce documents a while back. Can you explain to the court why you've not produced those documents?
Yes, one was a cash app, and I called them people, and I couldn't get them to send me out any kind of, a couple times, any kind of statement. And the bank one was, I just started that bank, and I was trying to get the statement from them too, and I never received my statement. I had to call them to send them, for them to receive a statement. I have received one since then.
You do have a statement from the bank now?
Yes, I do.
Okay,
I don't
so
have it with me now, but I can send that as soon as I look it up in my mail.
Okay, yeah, that was supposed to be provided to Mr. Smith.
Yeah.
We want it sent today.
Okay, I can send it out today. As soon as I find it here, I'll send it right out.
And Cash App sends regular statements to your email.
Yep.
Oh, my email. I never use my email. I have to have my kids get in it because I don't know how to use my email. So
Okay,
I have to have them, I have them find it and look it up.
Yeah, whatever email is associated with your Cash App, you'll automatically get a statement there.
Okay, I didn't know that's where it was at. I'm used to getting stuff in the mail, I guess. I didn't know that's where it was. I have my kids look it up for me.
Okay, Mr. Smith, did you want me to just give you another short date, reset this so that we can give her time to send those?
That'd be great, Your Honor. Just so that we're clear, under the subpoena, she owes, there's 3 accounts. She owes 6 months, the last 6 months of monthly account statements for Direct Express, the last 6 months of monthly account for Comerica, and the last 6 months of Cash App. And as long as those are provided before the date we're about to get from the judge, I can cancel that date, but I have to have those records to complete the examination.
You understand that, ma'am?
Yeah, I have to give them to you before the next date, you saying?
That would certainly be best, because if you do, then perhaps, assuming there's no further questions, you and I don't have to come back. But we're going to get a date today from the judge, and if you don't send everything you're supposed to send at the court order, then you and I will end up back here.
No, I'll try to send it, but Your Honor, I want to know why did he want to see my bank statements?
Because they're trying to figure out how they can get the money you owe.
And I told him I don't have any kind of job. All I have is my SSI. I don't know why he keeps harassing me about this. I have no money.
Well, but I don't know that we can qualify this as harassment. This is standard. It's discovery. When you owe a financial debt, they have the right to inquire into your financial history, including your assets, so they can see how they can get the money you owe them. The other option is to just pay them the money you owe them. So if you don't, then they have to figure out how they can get it.
And ma'am, Your Honor,
yes.
Can you tell me what is this he's saying that I owe, and when was that year of date, and how much I'm supposed to be owing him? I don't know anything. I don't even know what we're talking about. I asked him before, what is this complaint that he's after me about? And I don't even know what it is.
If you want, Your Honor, I can send her a copy of the original summons and complaint as well as the judgment, and then she can call with questions.
Correct. If you could do that, I'm looking up the file here.
I want Your Honor to look it up for me, please.
You bet.
Well, I was going to say this is an old file. The only thing they give me is the updated information because we're now digital. I would not have even been on this file when you more likely than not probably defaulted. It looks like it's LAFQ versus Kimberly McLeod or Kimberly Woods that you were served and sued on. You probably failed to appear, and there was a default entered.
If that was, Your Honor, it had to be 40 years ago. I haven't had anything with LAFQ in the last 20, 40 years. It has to be like that first car I had in 1980. I don't know what this is all even about.
And you owe, well, at least the last record I have a record here that you owe almost $40,000 on that debt.
Yep.
What cost $40,000? A car, a used Toyota? That's the only thing I had. And have they added it up over the years, or I don't understand.
Well, yeah, interest accrues, ma'am. It looks like the judgment on this is from 2016.
I don't understand.
So that would be, judgment was from 10 years ago, not 40.
I didn't have a car with them 10 years ago.
I don't know that this was about a car or not, ma'am. I couldn't speak to that.
I don't even know what it's about. Does it say what it's about,
Mr. Smith said he can send you the documents.
What does that mean?
They'll send you the documents as to what this matter was about, the original complaint that would have been sent to you for service.
Okay.
So he'll send that to you. I'm gonna reset this matter as well, so that you can have an opportunity to review the information he's provided, and you need to provide the documents that was subpoenaed, okay?
And that's my bank card, my bank account from Comerica, and a bank account from Indeed, which I don't have that anymore. Are they going to be able to give me something from that? I mean, express card, whatever the express cards come where your SSI comes on. Are they going to be able to find those old documents from that? I didn't have it that long. I just got on my SSI 2 years ago.
I'm not sure what you're asking or who's going to be able to find it. The bank?
Yeah.
Well, you got to ask the bank what they'll be able to find. I couldn't tell you what their statute is when it comes to how long they keep papers. You have to call them and find out. Okay, ma'am?
Yes, ma'am. Well, can you give me some time between these things, ma'am? So I can find the stuff, because I do want to get it taken care of.
Okay.
And I don't have $40,000. Not
January,
nowhere.
January 7th.
I don't have
Okay.
$7,000, ma'am. I'm on SSI. That's all I have. I'm barely making it myself. I don't get a lot of SSI pension. I just turned 60.
Ma'am, I recognize that. I recognize that you may be on limited income, but the party that the debt is owed to has the right to see and investigate to make sure that that's accurate, okay?
Yes, ma'am. I'll show them. That's all I got coming in that bank. I'll show them that. I wish I
January 7th
did.
at 8:30.
Pardon me?
January 7th at 8:30 in the morning.
Okay. That's coming up. Now,
Well, yeah, that is coming up, but that gives you about 3 weeks, okay, ma'am?
okay. After Christmas, that'll be able to get that? Okay. Okay.
Okay, we'll see you then, okay?
You said 8:30, ma'am?
Yes, ma'am.
Okay, I get them out to him as soon as I can.
Thank you so much.
Thank you.
You're all set on that one.
Yes, ma'am. Can I hang up now or should I stay?
Yep, you're free to go.
Thank you, ma'am.
You're welcome. I don't think that I see anybody from Pink Diamond Beauty. This is LabQ versus Pink Diamond Beauty, 15-01722. Anybody here on behalf of Pink Diamond? Okay, how do you want to proceed, Mr. Smith?
Tim Smith appearing on behalf of LAFCO. This was the time and place for the creditor exam of the registered agent of Pink Diamond, Katrina Balin. She had ample notice to appear back when it was originally scheduled. It has not appeared today. At this point, we would like a warrant against the registered agent, Katrina Balin, agent owner of Pink Diamond Beauty Mall. Proof of service in the court file would reflect service upon her. In fact, I talked with the original debtor, Lenitra Middlebrook, after service. She said she was going to call her friend to have her, who's Katrina, they work together, or Lenitra Middlebrook worked for Katrina, and have her call me to straighten this out. That was on October 18th. I have not heard from this person. I don't know why she's avoiding.
Okay, a warrant can issue. What is the past due amount?
The past due on this one, Your Honor, as of today's date, 38.17 and 89 cents.
You can do 25%.
We'll prepare and submit that. Thank you, Your Honor.
Thank you. You're all set. Mr. Dean, remind me again which one was it, Sparrow?
Yes, Your Honor.
Okay, and that's the matter you're here for?
Yes.
What's anything found after?
You haven't even noticed that the plaintiff attorney arrived late. So.
So you reset it?
Yeah.
Oh. All right, this is the matter of Sparrow Hospital versus, state your name. Can you come up to the counter, please? It's 24-03003. Council, can I have your appearance?
Michael Dean, P 81730 for the plaintiff, Your Honor.
Okay, the defendant is present in the courtroom. I think this matter was previously dismissed because the plaintiff was not present when the court called the case. I believe the representative for the plaintiff appeared later, so we reset this matter. Let's see.
That's similar to what I was told, Your Honor. I think they weren't let into from the breakout room, but
Well, that's not quite accurate. There was no one in the breakout room. However, we did later, once they appear, we advised them that we could reset the matter. Nonetheless, we have the person here in the courtroom. This was a motion that you filed originally, sir, to dismiss the case. You said it should have been covered by your insurance. Mr. Dean, did you want to respond to the motion?
yes, Your Honor, thank you. Whether the services should have been covered by his insurance as a statement by the defendant seems to imply that, yes, he did receive the services. One, any insurance billing or working with the defendant's insurance company is done as a courtesy service by the plaintiff and does not alleviate the obligation of the defendant to pay for said services. That is our position on the meritorious defense presented by the defendant.
Okay, well, I'm not following. So I don't think he's disputing that he got service at Sparrow. Is that correct? You're not disputing that you went to Sparrow for medical care? No. You produced insurance paperwork or insurance card at the time of that? Okay, and what makes you believe that it was supposed to be covered by your insurance company?
Because, Your Honor, I never paid for my medical expenses. I always had a full coverage insurance. Still, I have the it was fully covered, and it was just an ankle twist, so it's not like big surgery or anything. It doesn't cover my insurance.
You have proof of your insurance? So what was the date of coverage for this? Or this incident? What date was service provided?
The date of the medical services was August 16th of 2020, Your Honor.
2029? Or
2020.
Okay. Okay, this does indicate that you had coverage at least until November 2020 for full coverage. And so, counsel, what, I'm not following. You're saying that your client is not responsible for running his insurance, or he was supposed to make sure your client did that? What are you saying?
I'm saying that the insurance company has an agreement with the defendant to pay for his medical bills. If the insurance company, for whatever reason, decides not to pay incorrectly even, then that is on the defendant to enforce his contractual obligation with the insurance company, not for the healthcare provider who provided the services to force the insurance company to effectuate the contract that the defendant has made with them.
I agree. Are you saying that that's what happened in this case, or is this a hypothetical?
I'm at this point in time, it's a hypothetical, Your Honor. Is
No, well, I
motion
don't
to
want to talk about
dismiss.
hypothetical. Did Sparrow seek to get paid under his insurance or no?
I do not know. As of right now, we have not received his insurance documentation with his motion or any other way. We've had no chance to verify any of it.
And I could be, you gotta remind me, I believe that there, when you came before, you mentioned something about service. Did you get the lawsuit originally? I can't remember. Sir, I'm talking to you. Were you, when you were sued by Sparrow, why didn't you respond to the lawsuit?
So I already explained it. I cannot read it right.
Oh, that was what it was.
Language,
Language is an issue. Okay. Do you need an interpreter, sir?
I don't need an interpreter. I can speak, but I cannot read it right.
You can't read and write in English? Okay. Do you have an insurance card?
Insurance card?
Correct.
Right now?
No, at all. Did you have one when you went to the hospital to give to them?
Yes.
Okay. And you said it was for a twisted ankle?
Yes.
And I believe it was your brother or somebody that wrote the, because I think he came last time. Someone wrote the motion for you with assistance. Okay. Okay, well, in order for the court to decide, the court has to have one of two things, good cause and a meritorious defense. I think that if there was good cause, can't speak English, he's got limited reading and writing ability. He did report to court previously with someone else, which the court has a vague recollection of, but I do remember there being a language barrier and someone assisting him. And then the meritorious defense is he is provided a copy of his insurance. He's brought a copy here to court today, proving that he had full coverage at the time of the date of service. And that it was provided to Sparrow at the time. The plaintiff can't even determine or give the court explanation as to whether or not they attempted to seek recovery under that insurance policy and whether or not they were just denied, or if they just skipped right over it, which would not have been uncommon for Sparrow. I can't say that that wouldn't be the first time I've seen it, and instead has sought him to pay rather than going through the insurance. And so his motion is going to be granted. We're going to set aside the default. It does not dismiss the case. It set aside the default. Default means you failed to come or appear to court, so they automatically receive the request that they're making. We'll set aside the default. That'll give you an opportunity to talk with them off the record to see if this could be resolved by them getting your insurance information and running that, or any other resolution. If not, you have the right to proceed to a trial or a hearing if you'd like, okay? Is that a yes? Okay, because we have to hear you on the record, okay? I'm gonna set this for a pre-trial, but I'm gonna also get him on Zoom if you'd like, Mr. Dean, or we can get a copy of the paperwork that he has and have it scanned to you.
That would be great. Thank you, Your Honor.
January 9th at 2.
January 9th at 2 for a pretrial. Yes.
I have one more thing.
Yes.
And also I received a phone call from them like 6, 7 months ago. And I thought that's a scam and they were asking for debt collector. And they were asking like between $200 and $300 something. Now they like
You thought it was a scam, you said? A debt scam? Okay, it likely could have been a debt collector trying to settle the case, but with all that goes on over the phone these days, I can understand you would be leery if you received a call asking for payment over the phone.
Yeah.
I don't know what the nature of the call, but it's not uncommon for a debtor to reach out to try to settle the debt for a lesser amount, okay? Okay, we're gonna get you on Zoom. Do you have a phone with you? Okay, well, she'll assist you in getting on Zoom in just a moment so that you can meet with the plaintiff's attorney. What's your name, ma'am?
Michaela Potter.
Thank you.
Thank you. See, thing versus prior. That may be a file. A physical file. Yeah. I don't remember file. How does anyone do Facebook? And I have a consent judgment for the 230. Did you sign a consent judgment, ma'am?
Yes.
Is it supposed to be canceled?
Yeah, it's not on my docket. I printed one this morning and it was on there.
Okay, I think your matter was canceled because you resolved the matter, so you're all set. Thank you. Same to you.
This phone is not working properly.
on the record in the matter of Anthony Pryor versus Simon Zaney. And this is 23-02133 GC. Counsel, can I have your appearance?
Good morning, Your Honor. Attorney Cooper Dobies on behalf of defendant / counter plaintiff Simon Zaney, who is standing to my right and appearing by Zoom as well. And I am standing in for attorney of record Edward Zaney, both with Edward's permission and the permission of my client this afternoon.
Okay, today, Mr. Pryor, state your name for the record.
Anthony James Pryor.
Okay, present via Zoom. Today was the date that was scheduled for an objection to installment payment order. The defendant counter plaintiff has filed a motion for installment payment order asking to pay $150 per month. It says see attachment of first two payments. I'm not sure if the clerk's office sent that up, but they did put a note. Mr. Pryor, did you seek to give payment to the court? Is that what happened?
No, what happened is after I found out that the judgment was made, that it was entered against me, that you told me in person that I was gonna have to pay Edward that money. And so I tried communicating with Edward a few times by email with no response. And then I remember you telling me that I needed to probably just go to their office and make an arrangement with them to figure out how to get them taken care of. And so that's what I did. I just went in there and I took two payments because I had those two payments over the course of emailing them for a couple of weeks with no response. I still got the payments around and made sure that I got those to them. And so I just went and took them and dropped them off to him. And then I made a photocopy of them and put them in with my stuff that I gave to the court a couple weeks ago.
Okay, sounds good. And then the plaintiff, you are filing an objection to the installment payment order?
That is correct, Your Honor. Yes, that's correct.
What's the basis of your objection?
A couple of bases, Your Honor. Just to briefly highlight a couple of points in the motion or in the objection that we filed, the written response we filed with the court. The first issue is that the form that Mr. Pryor filed, this form MC-15, on its face, it was never properly notarized, which is required by the statute. And it even mentions it on the form. There's an area above where it says certificate of mailing. The copy that we have of it, it says subscribed and sworn to me on, and there is a date. There's no other notarization of it related to that. So I would just direct that to the court's attention first. We have no indication that Mr. Pryor himself is a notary, even if he was a public notary.
Excuse me, don't interrupt, please. We've gone through this, Mr. Pryor. Keep going, counsel.
Thank you, Your Honor. Even if Mr. Pryor was a notary, there's no indication on the copy that we have that it ever was notarized by anyone, whether it be the court or otherwise. There's no appearance of that. The second point I would like to make is that this matter is governed both by the Michigan court rules and statute. Specifically with regards to the Michigan court rules, we're looking at MCR 3.104. That court rule should be read in tandem with MCL 600.6201. And MCL 6.201 specifically states that a party in Mr. Pryor's position does not have standing to ask for a payment plan in this matter. Mr. Pryor was sanctioned under MCR 2.405D, and in that capacity, he was sanctioned as a plaintiff. So Mr. Pryor is a plaintiff. We understand that he is also a counter defendant, but he is a plaintiff that is attempting to reframe himself as a defendant for the purposes of attempting to enter a payment plan before this court for a judgment that was entered against him, again, in the capacity of being a plaintiff, not a defendant. The plain language of, as I mentioned, MCL 6.201 specifically states, and I'm quoting here, I'm taking a part of the statute here, upon proper showing made by defendant, unquote, an installment plan may be entered. Again, I would reiterate that in the capacity that Mr. Pryor had a judgment entered against him, he was acting as a plaintiff, not as a defendant, while still acknowledging that, yes, he was a counter defendant in this matter as well. not in the capacity, he was not acting as a counter defendant when he had a judgment entered against him. He was a plaintiff. The third point I'd just like to highlight again, Your Honor, and we did make this point in our pleadings, going to MCL 600.6205, that has a mandate, quote, the affidavit of the moving party setting forth his inability to pay the judgment with funds other than those earned by him as wages, unquote. Quite frankly, Your Honor, all that we have is a handwritten computation with, I would position, no substantiation as to how he got to those numbers. And quite frankly, Your Honor, there was a deposition of Mr. Pryor in this matter that Mr. Zaney undertook. And the sworn testimony at that deposition actually contradicts.
Mr. Pryor, Mr. Pryor, are you carrying on a conversation with someone else right now?
I was trying to tell my husband when he's standing in the window that I have to go get my daughter.
Okay, well, if the other thing is
I'm listening to him.
You can't operate a motor vehicle while you're in court.
I'm sitting in my driveway letting it warm up.
You can continue, counsel.
Thank you, Your Honor. The sworn testimony of Mr. Pryor at his deposition actually contradicts the computations that he provides the court, if the court is to believe those computations in the first instance. Mr. Pryor testified to having multiple stocks when he was asked what residual investments he has. He cited that he uses cryptocurrency to buy and sell stocks and that he has a crypto.com account. He was asked how he paid for the roof, which started this whole matter, and the court's familiar with that. His answer, and I quote, was, "I sold crack," unquote. And he also mentioned that he owns a house in Florida on land contract at 618 Southwest Racher, Racher Road. And in all candor to the court, I was not able to verify that address exists, but Mr. Pryor has made statements that he does own property in Florida. So this is all four of those sources of income are outside what he is earning by wages, and it's the position of plaintiff here, or I'm sorry, of defendant counter plaintiff here, that is all income that's outside of his wages, that it contradicts the attachment to the motion for an installment plan in this matter. And just finally, Your Honor, I would be remiss if I didn't mention this. I believe Mr. Pryor alluded to this a little bit in his initial statement, although I think it's a gross mischaracterization of what occurred. Mr. Pryor attempted to serve what I have, two MoneyGram orders that I have here. He attempted to pay these or serve these onto Mr. Zaney, Mr. Edward Zaney, that is, at his office. It was at his office. I would just like to note for the record that this took place before Mr. Pryor filed this motion for an installment plan. It was almost Mr. Pryor attempting to start his own installment plan without any sort of order from the court. And I would just like to note both of these MoneyGram payments are $150, which I believe is the exact amount that Mr. Pryor is attempting to start this installment plan with. So I think that's a bit too coincidental, as I mentioned. And again, Mr. Pryor was quite rude to the staff at the office here, the female staff at the office here.
Not at all. Not at all. I know you don't want me to interrupt.
I tend to believe it because he's rude in court. He won't be quiet while other people are talking.
I'm not rude in any way to anybody ever.
Talk again over the other party, and your motion is dismissed, and you'll be sanctioned for disrupting the court.
Yes, ma'am.
You can continue, counsel.
I would just like to wrap up briefly with a little bit of recap of what my final point there. That again, he was quite rude to not court staff, to our staff here in the office, who was not familiar with Mr. Pryor, was not familiar with his situation, was not familiar with his this relationship to this case. They merely were doing their jobs, and Mr. Pryor approached unannounced, might I add, in this matter. and attempted to again serve these, pay these two $150 payments in this matter. So again, Your Honor, we would just be asking that Mr. Pryor not be allowed to have this motion for installments for the multitude of reasons that I stated on the record and more thoroughly developed in our written response. Thank you, Your Honor.
Thank you. Mr. Pryor, now would be your opportunity to respond to their written objection to your motion for installment payment orders.
Yes, ma'am. First of all, I want to apologize to the court because for one, I believe that I'm always misunderstood.
Your connection is
I
bad.
went to their
so
office, see Nicole.
Sir, we lost you for at least 30 seconds there. Your connection is bad.
Okay, sorry. It's probably my battery's getting connected for a long time. Hello, are you there?
Yes.
Okay, so I'm usually misunderstood. People take me for what I say and do as attitude, and it's really not. It's usually just I'm a direct and I'm straightforward and I'm very passionate about what I do. I went to their office to make payments because that's what I know needs to happen. It was a direct intentional payment of $150 on both of those payments because that's what I was communicating with them that I could afford to make each time I made a payment. And during the interim of not being responded to, I made 2 payments, but I never delivered them because I thought maybe we'd get a response back from them, but I did not. When I went to the office, at their office, and Nicole was standing in is actually sitting at the desk, I specifically said that I was emailing Edward for the last couple of weeks with no response. I was in no way rude. She might not know me, as he stated, physically in person, but I believe she was there when I went to the deposition. And so she knows about my case, and she does very familiarize. She sent me emails about my case before because I've sent her emails about my case.
Okay.
And they
I don't
told
want
me
to talk about that right now.
okay,
That's
well,
really
I'm trying to
not...
cover all the points that he just
well,
made.
I'm trying to stop you, and you're going to let me stop you because I don't want to hear about it. I want to hear why you believe that you, per the Michigan Compile Law, you have the right to request an installment payment order as a plaintiff. That's what I want to hear about. I'm not finished. I'm not finished. I also want to hear more about your representation of your finances, because we do have a sworn statement under oath from you that indicates that you have multiple stock investments, cryptocurrency, some engagement in some unauthorized sellings, and property in another state on a land contract. And then I have a handwritten statement that you wrote about your finances, particularly one of the highest one on here would be a house payment. I could be wrong. Did we self-open an eviction for him, or was that closed?
I think they might have closed his house fire. Because what house fire his land contract and he did like not pay.
Yeah, my understanding is you don't pay that based on some court filing. So you need to give me some, those are the things I want to talk about. I don't really care about being rude in the office.
Okay, all right. So under oath, you're considering the deposition that I did at his office under oath. I was under very much stress. And I did say some smart remarks that weren't accurate. I made smart remarks to Simon and to Edward when they were there in the office, interrogating me and putting me on the spot about my previous history, about other things that had nothing to do with my roof. And so, yeah, I made some smart comments to him about doing some things that I shouldn't do there, that nobody should ever do. But that's because they know damn well what I do. They know exactly clear what I do for a living when I was working. This whole year, from February until the end of August, I didn't work because I was out on medical. And so I went back to work in the beginning of September. My finances that I wrote down in that list are exactly accurate to what I have going out the door. And what I have bringing in right now is less because I just got back to work. And so it's very accurate. I don't have the cryptocurrency that I have like $380, and it's on, I said crypto.com. That was a lie. It's on Robinhood. I've got like $382 on Robinhood. Originally back in like 2019, I had like $15,000 invested on Robinhood, but I lost a lot of it when all that stuff went through the roof, and I made some more investments to diversify myself, and then it all went back down. And so I lost my tail. I can prove that. I can log in, give you the information. I don't care about that. I'm paying every month for my house payment $1,000 a month. It's not going to the person that I'm making the deal with the house on, because we're having a disagreement about whether
it's a rental or it's a purchase. So in her consideration, it's a rental. And so in my documentation, it's a purchase. And in the fact that I win a case against her in the future, then that would be accurate. I may have some equity in my home eventually later down the road, and I don't have now. But that's not something that I have just floating around. I don't have any property in Florida. He miswrote the street name, and when he said it back to me, I let him say it back to me wrong. If you go back and listen to the deposition, I said Archer Court, and he said Rachel Road, and I just said yes. Yep, that's what it is. And because I was upset, I was angry. A lot of people misinterpret what I do and say as being rude or obnoxious or out of control, and that's not really who I am. I'm a good person. I help people. I spend every day of my life helping people, all day.
Sir, we don't want to hear about that anymore. You've told us
I know
every
you
time
don't.
you come into court. I don't want about you helping people, and you always want to construe it as you being misunderstood. But if you continuously talk over people, if you're aggressive, if you're threatening, if you're swearing, then you're not being misunderstood. You're being rude.
Okay, well, in their presence, in their office, under that situation, it was high stress, and that's just what happened.
Okay, what about the court rule? The court rule does not provide for a plaintiff to file for an installment payment order. You are not a plaintiff. I mean, you are not a defendant. You are a plaintiff in this matter. Did you have a response to their objection based on that?
The only response that I have to you is, I mean, I am the plaintiff in the original case. In the counterclaim against me for attorney's fees, I believe I am the defendant, and I should have rights to pay in a normal manner. I mean, I've already made an effort to do so, and I'll even make an even extreme. I'll give everything I possibly can, every chance I get to get it paid, because I don't want to have to file bankruptcy to just wipe it out completely. I could. I don't have anything else that would stop me. I mean, I could just do that. It'd save me all kinds of time and aggravation and headaches. I could just put it to rest with that. I don't have anything else, any other debts that would be affected by it. And I've already consulted an attorney. And I mean, I was trying to not do that, but.
Anything else you want to provide to the court for consideration today, sir?
No, ma'am. I do my best in everything I do. That's it. And that's all I can do. I don't have the money just laying around. I don't have any properties in Florida. I don't have any interest in anything that's just laying around that they can just come take from me and just go do what they wish with. I'm not that. One point years ago, when they knew me from a long time, that's the case. Yep. I could have just went given them money and just paid them. But no, that's not who I am today. I've been through a lot in the last decade. If you go through my personal history, you can look at my history. I think I filed bankruptcy once before. I've lost an entire business due to family taking it from me. At one point, it was worth millions of dollars. And so, yeah, at one point, I did have a lot of ways that I could have paid them immediately, but that's not today. Today, life is different for me.
Thank you. Thank you for your response. Counsel Dobies, I don't know if you had any further response, but I did want to respond on Mr. Pryor's behalf as it relates to the filing of his affidavit. It does not need to be notarized. It was signed by the clerk in the clerk's presence, and so that it was properly filed. My question or concern for you, Mr. Dobies, is how do you intend for Mr. Pryor to pay this? You think he's going to pay a lump sum to Mr. Zaney's office?
Your Honor, I think that there may need to be a debtor's exam in this matter, and I think that that's exactly how we're going to ascertain exactly what the situation is, because quite frankly, we don't know either. And part of my response to that is that, Your Honor, I believe Mr. Pryor admitted he committed perjury in his deposition. So we almost can't rely on what Mr. Pryor said in his deposition at this point, but based on his sworn statements at his deposition, we believe he does have assets that may be collectible in this matter. We just don't know yet.
Okay, so, well, it's your position that your office wants to proceed with a debtor's exam and get some discovery.
Yes, Your Honor.
What, you've not served him with such notice yet?
We have not yet. No, that may be a couple steps ahead of where we're at, but I believe that that's where this is going to have to go. Yes, Your Honor, that's correct. But we have not procedurally filed the appropriate paperwork for that to occur yet.
Well, I need to know, because I think that may have some bearing on how I'm going to proceed. If you're going to do a debtor's exam and do some discovery into his financial ability to make a payment, I think it's reasonable, even if he hadn't made statements that we now can deem as perjury. Just by nature of the fact that he owes a debt, you had the right to discover information about his financial resources. And so if in fact he's in a position where he can't do more than what he's offering, then I think he's being forthcoming, he's making that, and I would be amenable to granting him an opportunity to make installment payments, even though he's not deemed a defendant in this matter. But if it terms that maybe we don't know how to believe what he's saying because we don't know when he's being facetious or when he's being forthcoming, then maybe he does need to make a lump sum payment. I don't know. It may require an evidentiary hearing. I'm not sure. But I'm going to leave that to you in your office as to whether or not you want to proceed with a debtor's exam and subpoena certain documents to be produced so that you can know best how to proceed on your end. And then that'll let me know, because I don't want to sign this installment payment order and then your hands are tied as to garnishing and getting other things when we could have did some discovery first. Mr. Pryor, you're raising your hand. Yes.
Yes, I'll provide those documents to you willingly to save everybody the time. I'll give you my bank record. I'll give you the Robinhood records. I'll give you all that stuff. I'm not lying to you in front. I did that because I didn't feel like I was under oath and that wasn't like any kind of real. That was me being at their office being harassed to me at that time.
No, you were under oath under the penalty of perjury, sir. So if you lied, then that's unfortunate because that's perjury and there's a penalty for that.
I'm sorry, and I didn't mean that, but there was no judge in that room. So that's why I said what I said.
There doesn't have to be a judge in the room. It's just like if you sign something, you signed this paperwork when you came to the court, and they're saying that it wasn't notarized, but you signed it in the presence of the court, of the clerk. A judge didn't have to be there. You were supposed to tell the truth on that document. That's what you were certifying. Nonetheless, I recognize that you're willing to turn over certain documents. There may be other documents they may be willing to subpoena. I'm going to reset this to allow them an opportunity to subpoena the documents that they want you to turn over. You can turn those over. They can review it, and then we can have a follow-up hearing review for this. And I'll make either a ruling or maybe they'll be satisfied at the time of their next hearing date to see that this is probably the only way they're going to get their money. They may see your finances and realize there's nothing else that they can get. Do you understand, sir?
Yes, I'm not lying to you in any way. So yes, ma'am, I understand.
All right, give me a new date.
January 17th at 2.
Does January 17th at 2 work?
Your Honor, just one moment. Let me pull up our calendar here. January 17th at 2 p.m. you said, Your Honor?
Correct.
That does work.
Okay, we'll set this out for then. In between the Mr. Pryor, you should expect to receive a subpoena from their office for certain documents that you could turn over to them. And you said you're willing to do that. You should do that immediately. That'll give them time to review it before our next date of January 17th so that we know how to best proceed on your motion, okay?
No problem. Thank you.
Okay, any additional matters for today's record?
No, thank you, Your Honor. None from our side.
Anything else from you for today, Mr. Pryor?
No, I appreciate you, ma'am, and I hope that you understand like what I meant by being under distress and saying what I said in their office. And it was very uncomfortable for me to be there. So I
Okay,
thank you.
you're all set for, thank you. You're all set for today.
Yeah, bye.
Thank you.
And then these parties are, Mr. Dean, you met with the defendant on this matter. Did you need to go back on the record for anything at this time, or are we continuing to pre-trial?
We'll continue to the pretrial, Your Honor. There's just the matter of funds, I guess. Those should be returned to the defendant. Is that correct?
There was a garnishment. Is that what the issue was?
Yes, Your Honor.
Okay, yes, I need an order for the it to be released. I thought it was already in the system released though.
It shows on the 13th garnishment.
To defend it?
It doesn't say which.
Okay, let me
Yes,
see.
release liability to DO1, yes.
Yeah, I think we already have released that as of the 13th to the defendant.
That might have been released because it was paid. Essentially, it's paid in full. I think there's $15 remaining, so it might have been canceled as a low balance, but we've collected.
Yeah, I'm not sure. Let me see here. The 13th. Let me see if I can find the file. There we go. Garnishment release wage. That's what I see. So the wage garnishment was released. And you said that's because it was paid in full.
I believe so, close enough that that's what happened.
Okay, that's likely what happened. That's all I see is that a release for the garnishment. You're no longer under obligation. Okay, so your client has already received payment, however, let me have can your office post that in escrow with the court?
I believe so, Your Honor.
Okay, and that way, they'll be here until we can determine where it properly should go.
Thank you, Your Honor.
Okay, so I'll note that will be how we proceed on that. And then we already gave you a pretrial date, so we'll see you both at the date and time of the pretrial, okay?
Thank you, Your Honor.
Thank you, you're all set. You're all set. You said, can I repeat? The money that they've garnished, they're going to post that back with the court in escrow until the court makes a determination about the lawsuit. We have a pretrial date that's going to come. You got that date already? And so you'll appear on the pretrial date. I don't know if you all discussed or we provided them with the information about the insurance, but you should provide them your insurance information as well so they can see if they can get that covered through your insurance, okay?
Thank you.
Thank you, you're all set.